Welcome back to this week's episode of The Emily Show. There's lots happening in law, and the Karen Read trial is entering week 8. I know, I can't believe it either, but we're still here, and it looks like we're going to be in Massachusetts a bit longer. But there's lots happening in law elsewhere. In New Mexico, prosecutor Carrie Morrissey is asking for Hannah Gutierrez to be given use immunity. That hearing is coming up later this week on Friday, June 21st. So we're going to take a look at what she thinks Hannah Gutierrez Read will testify to if she testifies at Alec Baldwin's trial in July. There's a lot going on in the YSL Young Thug RICO prosecution in Georgia. You may have heard a thing or two about an attorney being arrested in court and held in contempt. And now the Georgia Supreme Court is involved. We're going to talk about that. And back to South Carolina, where Buster Murdaugh is suing Netflix, HBO Max, and others for defamation. It's a lot today, so let's get into it. Welcome to The Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. A huge thank you to Thrive Causemetics for sponsoring today's episode. Thrive makes luxury cosmetics simple while still giving back. Not only are the ingredients certified 100% vegan and cruelty-free, but they are also effective. I love the Brilliant Eye Brightener. It's what I use to not only highlight under my brow, but as eyeshadow every single day. And when I am traveling, just carrying around the sticks makes it so easy to take my makeup routine on the go. There are more than 16 buildable shades, and they have everything from lights like Stella that you can use to highlight your brow or inner eye to beautiful, lush metallics. And of course, you can complete that look with their incredible Liquid Lash Extensions mascara and Infinity waterproof eyebrow liner. So as you are getting active in the summer, you don't have to worry about the brows going anywhere. Are you ready to refresh your everyday look with luxury cosmetics that gives back? If so, it's time to give Thrive a try. Right now, you can get an exclusive 10% off your first order at thrivecosmetics.com/Lawnerd. That's Thrive Cosmetics, CAUSEMETICS.com/Lawnerd for 10% off your first order. Let's get back to today's episode. First, quickly going to New Mexico to look at Carrie Morrissey's motion asking the court to grant Hannah Gutierrez use immunity, meaning she could testify at Baldwin's trial without worrying that what she says in her testimony could be used against her or would be used against her for either future prosecutions or if her appeal is granted and she is retried. So Carrie Morrissey is pointing out that she has reason to believe Hannah Gutierrez will plead the fifth and why. And in this motion filed on June 14th, Carrie Morrissey says, facts. After the shooting death of Helena Hutchins by Alec Baldwin, Hannah Gutierrez provided several statements to include a statement to law enforcement on November 9th, 2021, another statement to OSHA investigators on December 16th, 2021, and in a statement provided November 9th, 2021, Gutierrez waived her Fifth Amendment privilege with the assistance of her attorney, Jason Bowles, and made numerous statements that the state now seeks to use in its case in chief against Alec Baldwin. Remember, we watched that entire statement with Bowles just sitting there. I don't know what he was doing on his phone, but on his phone, kind of taking notes, kind of not, the entire time. And the statement on December 16th, 2021 to OSHA was also with Mr. Bowles, where Hannah's Fifth Amendment rights were never raised or discussed. Probably because when speaking to OSHA, they know that OSHA was focused more on production and employers, but any statement made about the case could be used against her. So it's interesting it didn't come up. It says the statements the state seeks to introduce do not inculpate Ms. Gutierrez. They are statements made by Ms. Gutierrez that inculpate Mr. Baldwin. The state then goes on to say that in conversations with attorneys, they believed that Hannah Gutierrez would not need use immunity and would not be asserting her Fifth Amendment privilege. And then they go through the scheduling difficulties to eventually interview Hannah Gutierrez on May 14th and said that during the interview, Gutierrez asserted her privilege to numerous questions that arguably did not expose Gutierrez to criminal liability. Morrissey goes on to say that on the evening of May 14th, she emailed Bowles and indicated that she intended to ask for use immunity for Ms. Gutierrez, which explains why he knew that that was coming when he was speaking in Nashville. He responded that same evening that use immunity would, quote, take care of any issues, but that he wanted to think about it overnight. He indicated that he would confirm his position with undersigned counsel the following day. He probably needed to speak to his client. It goes on to say that he never followed up with Carrie Morrissey. The state then goes on to list out why they believe that Hannah Gutierrez will seek to plead the fifth to at least some questions. Remember, it goes question by question, and writes, in the instant case, the state seeks information from Hannah Gutierrez regarding the criminal culpability of Alec Baldwin. It says during her pretrial interview on May 14th, Gutierrez was asked what it was like to work with Mr. Baldwin. Was he easy to work with or difficult to work with? She asserted her Fifth Amendment privilege. She was asked if she conducted firearms training with Baldwin and was asked follow-up questions about what training consisted of. She asserted her Fifth Amendment privilege to all questions regarding the training. She was asked if Baldwin was attentive during the training, using his cell phone, making any videos, or FaceTiming family members during the training, and she asserted her Fifth Amendment privilege. She was asked if Mr. Baldwin's holster was available for the training and whether she discussed a subsequent training session with him, and she asserted her Fifth Amendment privilege. She also asserted her privilege regarding questions about whether Baldwin rushed her, whether he was in charge of the movie set, whether she initially offered him a fake gun on October 21st, 2021 to rehearse with. Most of those questions were freely answered during previous interviews after she waived her Fifth Amendment privilege and voluntarily gave statements to law enforcement and OSHA. The state is asking the court to determine the questions to which Ms. Gutierrez can assert her Fifth Amendment privilege under the law. For those questions that the court determines she has a valid right to assert her Fifth Amendment privilege, she should be granted use immunity and be ordered to testify. Ms. Gutierrez possesses highly inculpatory information about Baldwin, and the jury's role is truth-seeking, and that should not be infringed upon. The state goes on to say that Gutierrez previously stated that Baldwin was not supposed to be cocking the gun or pulling the trigger during the rehearsal that resulted in Miss Hutchins' death, and previously stated that Baldwin was largely inattentive during firearms training and was speaking to family members on the phone, sending text messages, and making videos for his children during the training. Previously stated that she instructed Baldwin during the training sessions not to point the gun at others, to keep his finger off the trigger and out of the trigger guard. Previously told law enforcement that because Mr. Baldwin was a producer on the film, he, quote, kind of does whatever he wants, so the other producers have to reel him in all the time. She explained to OSHA investigators that Baldwin was not available for firearms training with the other actors. In a text message from October 17th, after a day of filming where Baldwin had numerous outbursts, Gutierrez described him to a fellow crew member as crazy. And it says, finally, in a recorded jail call, Gutierrez indicated that she offered a fake gun for rehearsal on October 21st, 2021, which is new information for us. The state goes on to say that Baldwin's defense attorneys are well aware of what Gutierrez has said and that the state would seek to use those statements. And the defense never notified the state that Gutierrez was intending to assert her Fifth Amendment privilege upon listing her on their witness list and scheduling a pretrial interview. In fact, defense counsel stated to undersigned counsel that Gutierrez would answer questions posed during the interview. And the state goes on to talk about Gutierrez's response to the state's motion for immunity, saying that she cannot or should not be forced to testify. The state says that what Gutierrez asserted in her response was that somehow her testimony in the Baldwin trial would expose her to heightened criminal culpability in her pending case due to the high-profile nature of the case against Mr. Baldwin. Your Honor, she doesn't want her testimony to be on TV. It goes on to say Ms. Gutierrez seemed to assert that she would be unable to obtain a fair trial in her pending case for a completely unrelated incident if she were to appear to Mr. Baldwin's trial and testify truthfully regarding the culpability of Baldwin. It goes on to say if there was any real danger that Gutierrez would be unable to get a fair trial in her pending case, there was a remedy under the law, change of venue. It then says she's free to file that motion if she is able to demonstrate that her fear is based in reality. It then goes on to say that Gutierrez is arguing that assuming she wins her appeal and is granted a new trial, she will be prejudiced by the statements made during her potential retrial, claiming that, quote, once the statements are out of the bag, their origin is irrelevant. Well, the shit's kind of out of the horse on that one too. All of her interviews with law enforcement were played during her trial. The state goes on to say any statement that could potentially incriminate Hannah Gutierrez is already out of the bag. The shit's well out of the horse. The state goes on to say Ms. Gutierrez provided 4 statements after the death of Ms. Hutchins, and that those statements were played to the jury during her trial, which was also viewed by millions of people online and rehashed in countless news stories. This argument is nonsensical given that the state wants to extract testimony from Ms. Gutierrez that is inculpatory to Baldwin, not Gutierrez. It also said that if she was granted use immunity, the state would be given a free pass to cross-examine her on any topic it wanted. The state responds, this is simply not how evidence and testimony occur at trial. There's that Carrie Morrissey snark that we keep seeing. There it is. In the legal filing saying, that's not how any of this works. I mean, she's not wrong. It goes on to say neither party has ever given a free pass to ask about any topic. The court can limit the state's questioning of Gutierrez to specific questions about Baldwin's culpability and can afford Baldwin's attorneys adequate room to question her about her own culpability in the death of Ms. Hutchins that give rise to Baldwin's defense regarding proximate cause. The vast majority of this testimony is out in the public already. Ms. Gutierrez admitted to loading the gun, identifying the box of dummy ammo she was pulling rounds from that was later matched to a photo of rounds provided by her father, left guns unattended, did not conduct proper safety checks of the guns. And moreover, Baldwin's attorney intend to fully elicit all testimony that Gutierrez provided to law enforcement that implicates her. They just intend to elicit it in a vacuum under the hearsay exceptions pertaining to statements against interest, and the world will be watching. An interesting statement when it seems Hannah Gutierrez's concerns are exactly that. But the world will be watching is in the state's motion, nevertheless. They go on to say the world will be watching whether the court allows the state an opportunity to ask its questions of Gutierrez or only permits Baldwin to elicit one-sided testimony in a vacuum. The effect on Ms. Gutierrez is the same. Her incriminating statements will be aired during yet another high-profile trial. There is no constitutional injury to Ms. Gutierrez by the state's extraction of inculpatory statements about Baldwin's conduct by Gutierrez. The injury comes from Baldwin's right to present exculpatory evidence related to Gutierrez's criminal conduct that tends to lessen his own culpability, but Baldwin is entitled to present his defense. None of the defendant's arguments hold water against the truth-seeking and fact-finding mission of a jury during trial. So in the state's response, we've gotten both the shits out of the horse and no, the defense is wrong. Their case doesn't hold water because the my cousin Vinny of it all. Yes, Baldwin's trial is going to be a higher profile trial than Hannah's was because of Baldwin, but we're going to see a lot of the same witnesses that we already saw. And either way, we're going to either see Hannah testify or we're going to see the same interviews that we saw during her trial. Speaking of trials that are being televised, let's talk about the Young Thug case. I covered this case briefly as it began and was going to be checking in on this case from time to time. And it has not only been wild, but there is so much to keep up with. This is a massive racketeering case out of Georgia. It is a state case where this trial is 7 defendants, but 28 defendants have been indicted. They have had issues up one side and down the other. Jury selection started in January of 2023. The jury was finally seated in November 2023. This series of events just happened starting last week when the judge got into it yet again with the lead defense attorney, Brian Steele, who is the defense attorney for Jeffrey Williams, aka Young Thug. So I'm sure you have seen the clips at this point of he and the judge going back and forth about whether the judge is going to hold him in contempt, which he did, whether the judge was going to put him in handcuffs, which he did, whether the judge was going to sentence him to jail time, which he did. Since that happened, one of the other defendants filed a motion to recuse the judge, who is the chief judge of this courthouse. Then we saw the Georgia Supreme Court getting involved, saying that they were going to be taking up the contempt on appeal, and they granted a bond for the defense attorney, meaning he does not have to go turn himself into custody to serve his 20 days over the weekends while he's in the middle of this murder trial. And then on June 17th, we saw Jeffrey Williams, through his attorney, file a motion to disqualify the judge and a motion for mistrial. So we're going to take a look at that motion for mistrial, which lays out the ex parte conversation between the judge, a sworn witness, and prosecutors that defense argues is at the heart of this issue. It is shocking the way this all went down. It is absolutely stunning that a judge would have this type of an ex parte communication with a sworn witness and prosecutors without any defense attorneys for any of the defendants being present. It is completely improper. And I really don't know how they get around a mistrial at this point. And with a case that has already had this many issues, has called 60 plus witnesses, has already lasted over a year when you count the jury selection, where do you go from there? The reason I am not saying alleged ex parte communication is because when you watch this hearing go down, the judge is trying to force the defense attorney to tell him who told. The judge was sitting on the bench. Isn't it appropriate that Sutton Strack is from Georgia? Channeling his full Sutton, basically saying, name them. You won't go into custody if you tell me who told you about the in-chambers ex parte. Over and over. Just tell me who told you. Just tell me who. Name them. Name them. If that ex parte didn't happen, would the judge care who said something about it? And one of the key things to me in this is that the judge said, you seem to know exactly what was happening in my chambers. So that indicates to me that this ex parte conversation did in fact happen, and not only happened, but went down pretty close to the way the defense attorneys believe that it did. So let's take a look at the facts surrounding this motion for mistrial right in the middle of a massive RICO prosecution. Thank you to today's sponsor, Lume. Look, we know it's heating up out there. It is summertime and it's heating up inside all the courtrooms that we're covering. But if you want to make sure that the BO stays at a minimum, even when the weather is at a maximum, let's talk about Lume. Lume whole body deodorant is formulated for all the places that tend to get stinky when the weather gets warm, from your pits to your feet and everything in between. Not only can it go where deodorants don't, it is outrageously effective. One application in the morning is clinically proven to block odor all day for up to 72 hours of odor control. Are you ready to make this your freshest summer ever? It's time to check out Lume. As a special offer for our listeners, new customers get 15% off all Lume products with our exclusive code. And if you combine that 15% with the already discounted starter pack, that equals over 40% off the starter pack. And if you get that starter pack, don't forget to check out my favorites, the deodorant wipes and the body wash. All of it works together to help control odor. Use code LAWNERD for 15% off your first purchase at lumedeodorant.com. That's code LAWNERD at LUMEDEODORANT.com. Let's get back to today's episode. And again, this was filed June 17th, 2024, so just a few days before you will get this episode. It says, undersigned counsel represents Mr. Jeffrey Williams in the above referenced case. The jury trial of multiple accused persons commenced on January 4th, 2023, before Fulton County Superior Court Judge Glanville. The trial is expected to last at least through the end of the 2024 calendar year. In other motions, attorneys have indicated that this trial will last well into 2025. It goes on to say on Monday, June 10th, within 5 days of the filing of this motion, the court, along with the prosecutors, engaged in an unlawful, improper ex parte meeting with, among other persons, sworn witness Kenneth Copeland, for whom an order of use immunity had been issued on Friday, June 7th. No notice of this ex parte meeting was provided to any attorney for any of the criminally accused in this case. In fact, the accused and their counsel were in the dark as to this quote unquote star chamber meeting. Mr. Copeland had previously been called to testify on Friday, June 7th, asserted the Fifth Amendment privilege in open court in front of the jury, and was held in contempt, and summarily incarcerated until such time as he agreed to testify pursuant to the grant of use immunity. So, that's not uncommon in RICO prosecutions, especially when the RICO organization is alleged to be a criminal street gang. That's not uncommon that somebody's like, I'm not saying anything to any of you. I don't care what you want to do, but I'm not saying shit. So I'll take the fifth, put me in jail. That surprises me none. It probably surprised the prosecutors, none. It probably surprised the defense attorneys, none. It said Judge Glanville and the prosecutors essentially admitted by silence and by statements in open court that an ex parte meeting occurred the morning of June 10th, only after undersigned counsel revealed, based on information and belief, because they weren't there, so this is based on what they have been told, that this impermissible meeting occurred. Footnote 1. A transcript of the relevant proceedings on June 10th has been ordered from the court reporter. A video recording of the entire June 10th proceeding can be accessed online, and then it has a link to the YouTube video, because of course it does. Because televised trials. Look, this is one of the reasons cameras need to be in court. Because when stuff like this happens, I don't know if I would have wrapped my head around exactly how this went down without watching the judge say, but who told you? No, but who told you? You know an awful lot about what's going on in my chambers. I would have been like, what? It's mind-boggling. And especially when things happen in court that are seeming abuses of power, you have to be able to see it for yourself. It's why transparency in the courts, and all courts, is so needed. It goes on to say at the earliest opportunity on the afternoon of June 10th, the court was informed, based on information and belief, that the ex-parte meeting with sworn witness Kenneth Copeland and the prosecution occurred earlier that day, that the witness made factual admissions, and that the statements were made to and witnessed by the court and prosecutors acting in concert, and the amount of time Mr. Copeland could be held in custody on the contempt. The court denied undersigned's counsel request for a transcript of the ex parte and denied the motion for mistrial based on this improper and illegal ex parte meeting, which violated Mr. Williams' constitutional and statutory rights, including the right to due process, fair trial, fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceeding under the Georgia Constitution. I don't think it's arguable that this meeting with a sworn witness is a critical stage of the proceedings. It goes on to cite the code that prohibits ex parte communication, and what ex parte means is one party. So one party out, one party in. So the judge can't just have a side conversation with the prosecutor or defense attorney about substantive matters. If the prosecutor needs to come into court and say, there's been a family emergency and I need a brief continuance, I don't know why you couldn't say that in front of the other party, but if somehow it was needed to be communicated to the court, those types of scheduling and administrative things can generally be communicated within rules and limits, but nothing substantive, certainly nothing as substantive as a sworn witness making admissions and being told that they are going to receive more jail time. They then go on to delineate the amount of times the defense attorneys tried to rectify this with the court, saying the trial court rejected Mr. Steele's request for information about the unlawful ex parte, and the court denied the motion for mistrial. Instead, the court stunningly demanded to know how undersigned counsel came into possession of the information about the ex parte meeting. The prosecutors stunningly sat mute and permitted this injustice to occur and for the court to attempt to intimidate undersigned counsel. Later, Love, a lawyer currently employed with the Fulton County DA's office, argued that the ex parte hearing with witness Copeland was ethical, just, and proper. The other prosecutor still remained mute. It goes on to say that undersigned counsel declined to join in the antics in ignoring rules and ethical provisions and declined to provide information requested by the court, relying on the state bar rule of professional conduct. And then they go through the rules that the defense attorney is saying, I cannot disclose what I learned in the course of representing my client. That is work product privilege. I am representing my client. I learned something. I don't have to tell you how I learned it, where I learned it, what I learned. I need to tell you that I learned it and that it's a problem. And he goes out and lists through those rules. It said the court ignored the ethical rules relied upon and continued to demand undersigned counsel to reveal the source of the information, claiming that the way the undersigned counsel obtained the information was somehow unlawful, and baselessly accused undersigned counsel on the record of potentially acquiring the information through quote-unquote eavesdropping. When someone's accusing you of eavesdropping, doesn't it lend credence to the argument that you knew exactly what was happening? So much so that they believed you actually heard it firsthand, not secondhand. It goes on to say, in response to the specious accusations and impermissible demands of the court, undersigned counsel relied on the ethical mandates of the rules and said nothing. It said the court is so biased against the undersigned counsel and or Mr. Williams that the court ignored all laws and pursued contempt penalties to attempt to intimidate undersigned counsel to violate the law and ethics in order to continue to help the prosecution convict Mr. Williams and others. And as the defense attorney was like, this is privileged information, the court's like, you won't have to spend time in jail if you just tell me. Just tell me. Maybe sitting in jail will, make you change your mind. It was wild. And then they list out the different orders, including the court issued a written contempt order of incarceration, imposing the maximum sentence of 20 days. The Supreme Court of Georgia issued a writ of certiorari to address the appeal of the contempt order and has granted a supersedes bond, which means he does not have to go and serve jail yet. It's basically an appeal bond, but this is a writ, not an appeal, but same. The court violated the law, they say, by failing its duty to recuse from presiding over the contempt proceeding, which is like a basic. You don't get to preside over your own contempt. This judge is a witness to the contempt proceeding. It says in such proceedings where the announcement of punishment is delayed and where the contemptuous conduct was directed toward the judge or where the judge reacted to the contemptuous conduct in such a manner as to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge, which logically just makes sense. If this is a direct contempt, the judge is saying, I'm telling you to do something, you're not doing it, you're in contempt. Another judge hears it and decides. Not the same judge who says, you're in contempt of me. So the court should have recused itself, but the court shouldn't have had the conversation in the first place. The attorney then goes and lists out the numerous times that he has asked the judge to recuse himself during the course of this trial. And it has been numerous times that this attorney has asked the judge to recuse himself off the case, arguing that this judge has personal bias against either the attorney or the client, young thug. The defense goes on to say that the court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, judge, grand jury, biased, partial, potential sentencer, and thus must be removed from this case in toto instanter, completely and immediately, not toto, I'll dance the reins, not the group. They go and list out the legal grounds for the motion to disqualify and recuse, and then get into the rest of the motion to dismiss. In the attached exhibits, they included the order of contempt and incarceration, and the court said during the proceedings on the afternoon of June 10th, Brian Steele took to the podium and stated to the court that he had been informed of an ex parte communication which took place in the court's chambers that morning. The only parties present for this ex parte matter were the court, the court's official court reporter, representatives from the state's witness, Mr. Kenneth Copeland, and counsel for Mr. Copeland. So even in the order, the judge is like, yes, this ex parte happened. It said, in addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. The court, having told Mr. Steele multiple times that he needed to tell the court how he came into that information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court finds Mr. Steele has repeatedly refused to follow the court's order. Well, Your Honor, when the court's order goes against the attorney's ethical rules of conduct, I'm not surprised that he chose his bar license and 20 days in jail as a penalty versus breaking his ethical duties to his client. Like, that doesn't shock me. What shocks me is it got this far at all. And the court finished with, accordingly, it is hereby ordered that pursuant to the court's authority, the court holds Mr. Steele in direct criminal contempt for failure to comply with the order. It's ordered that Mr. Steele shall be taken into the custody of the Fulton County Sheriff and incarcerated at Fulton County Jail for no more than 20 days for this contempt, with those 20 days consisting of every weekend for the next 10 weekends, while he's in the middle of a massive RICO trial. Sure. Sure, Your Honor. The defense also attaches a affidavit of attorneys Brian Steele and Kenneth Adams. And in that affidavit, they listed out what they had put in their entirety of the motion, the whole order of events as it happened from their perspective. I don't know what the court will do with this. I don't know what will happen on the writ at the Supreme Court, but I imagine that the Georgia Supreme Court is going to act pretty swiftly in this matter. And that writ may well get granted. And when this motion for mistrial gets denied by the court, I wonder if that will also have a writ that will go up pretty quickly and be decided by a higher court. Absolutely wild in the middle of this massive trial that has been in trial since November and in jury selection since January 2023. But speaking of televised cases, we're back to South Carolina to talk about the Murdaughs. And for the moment, it's not about Courthouse Becky. This complaint was filed on June 14th, 2024 in South Carolina. Richard Alexander Murdaugh Jr., Buster, against Blackfin Inc., Warner Brothers Discovery Inc., Warner Media Entertainment, Campfire Studios, The Cinemart LLC, Netflix, Garnet Company, and Michael M. DeWitt Jr. The sum and substance of this defamation action are that it has been insinuated in numerous documentaries that Buster was somehow involved with the death of Stephen Smith. So we're going to take a look at the facts as they are laying them out in this complaint, but I have to wonder if Buster really wants to subject himself to the discovery that is going to come from filing this lawsuit. Netflix is like, yeah, whatever, just people sue us. That's just where we're at. Should we rename the show to be like Netflix gets sued? It's Wednesday. Netflix has been sued again. I'm only partly teasing. The lawsuit starts in sub and substance with on July 8th, 2015, Stephen Smith. This says, quote, whose car had given out of gas. Somebody did not spell check. Was walking along a rural road in Hampton County, South Carolina. It was late at night. As he was walking along the road, he was allegedly struck by a part of a vehicle and killed. News sources now report his death is being considered by a statewide grand jury, and the media has reported on individuals unrelated to plaintiff allegedly being involved in his death. The plaintiff, even though he has been falsely accused of harming Stephen Smith as described below, has not been notified by any law enforcement entities of any allegations against him related to Stephen Smith's death. On or about June 17, 2022, defendant Warner Brothers Discovery began streaming and broadcasting a series, Murdaugh Murders Deadly Dynasty, throughout the entire country, including South Carolina, on Discovery Plus and the Investigation Discovery channel. Doesn't that go by ID now? I don't know. Maybe. They say that it falsely suggests and subtly accuses, interesting language in a defamation suit, subtly accuses the plaintiff of being the murderer of Stephen Smith. During a 10-minute segment of the show, plaintiff is alluded to a number of times as the murderer of Stephen Smith. It says that the statements about plaintiff are defamatory and falsely accuse plaintiff of committing a crime of moral turpitude. So it gets you into that defamation per se category. It goes on to say false statements have been published to hundreds of thousands, if not millions, of viewers who watch the show, including viewers in South Carolina. It then says that defendant Blackfin Inc. created and produced the series Murdaugh Murders Deadly Dynasty. And so that is why they are included in that. It then says, beginning on November 3rd, 2022, defendants Warner Brothers Discovery and Warner Media began distributing and streaming a 3-part series to the public on the Murdaugh family entitled Low Country, The Murdaugh Dynasty, through Warner Brothers Discovery's platform HBO Max, now entitled Max, throughout the entire country and specifically within the state. The series publishes false statements that suggest that plaintiff, along with others, murdered Stephen Smith by striking him with a baseball bat. A sequence in the show accuses the plaintiff of killing Stephen Smith because of his sexual identity and further insinuates that the plaintiff killed Stephen Smith in relation to a romantic relationship between plaintiff and Smith. These statements are untrue in their entirety. It then goes on to say these statements are defamatory in that they falsely accuse the plaintiff of committing murder. The false statements have been published to hundreds of thousands, if not millions, through the Max channel. It goes on to say defendant Campfire Studios created and produced the series Low Country, The Murdaugh Dynasty, and in doing so, published the above described defamatory statements concerning plaintiff. It goes on to say on February 22nd, 2023, Netflix began a streaming series entitled Murdaugh Murders: A Southern Scandal, which depicts a young man with red hair carrying a baseball bat. The plaintiff has red hair and is readily ascertainable from the content of the series that the creators were depicting the plaintiff as the murderer of Stephen Smith. The series publishes statements such as, quote, everyone keeps coming up to me and saying it was the Murdaugh boys, and, quote, listening to these statements, it's pretty clear Stephen's death is intertwined with the Murdaughs. The series falsely contains statements that the plaintiff was engaged in a romantic relationship with Smith and that it was plaintiff and maybe two other individuals who killed Stephen Smith. It then states that defendant Cinemart LLC created and produced the series Murdaugh Murders: A Southern Scandal for Netflix and published it on Netflix. It then says Michael DeWitt Jr. is the editor of the Hampton County Guardian, a local weekly newspaper covering Hampton County, and that he appeared in the Netflix series Murdaugh Murders: A Southern Scandal. So they are suing him for the things that he said in the Netflix series, which is interesting because no one else who gave statements is named in this. This is the only individual named. They also name, of course, the publisher of the Hampton County Guardian, arguing that he is the owner of the Hampton County Guardian. In the documentary, he states, quote, we were hearing all these rumors about a possible connection. Quote, there is some truth to it. Quote, we could not put the Murdaugh name in the story unless we wanted to face lawsuits. We said a prominent, well-known family was rumored to be involved. Everyone knew who we were talking about. We published the story and we waited. People would come up to me in the Piggly Wiggly and pat me on the back. We're so thankful you had the courage to run the story. We did everything but put the Murdaugh name in the story. So when you're looking at defamation by implication, the statements are, we did everything but put the Murdaugh name in the story. So it was readily and easily ascertainable that it was about the Murdaughs. It then went on to say, I began to have a bad taste in my mouth about the members of the Murdaugh family, as many people in the community did. Context is going to matter quite a lot in this defamation case. I will make one note about this because I'm sure some of you are going to both ask me and ask yourself, but Emily, some of these things are from 2022. Yes, the first complaint of production is the Murdaugh Murders: Deadly Dynasty from June 17th, 2022. Note this lawsuit was filed on June 14th, 2024. The statute of limitations in South Carolina for slander and libel under South Carolina Code 163550 is 2 years. So yes, this was filed 3 days before the tolling of the statute of limitations against the first publication, Murdaugh Murders: Deadly Dynasty. So we will see where these go, but Buster is bringing a lawsuit against Netflix, HBO Max, Discovery, and others. I imagine that when this goes to Discovery, it might open a can of worms that maybe wasn't anticipated. Maybe it won't. Maybe the insinuations are too strong. Maybe there's no basis to them, and this goes forward, but it's going to be real interesting to see how this one plays out. You're going to have to let me know if you want me to keep following what's going on with Buster Murdaugh suing everybody that's talking about him. A huge thank you to today's sponsor, Shopify. Not only does Shopify run the Law Nerd shop, but also so many of your favorites across the internet, whether you're buying your favorite nail polish or picking up something from Brooklinen or Allbirds. Shopify is the global commerce platform that helps you sell at every stage of your business, from just getting started to your first sale to moving past 1 million orders. Shopify is there to help you grow every step of the way. And did you know that Shopify actually has little shopping bag Shopify awards? They're kind of like the YouTube creator play buttons. They're super cute. I cannot wait to earn one. So no matter what you're selling, Shopify helps you turn shoppers into buyers with the internet's best converting checkout. It's no wonder Shopify powers 10% of all e-commerce in the United States. Plus, if you ever get stuck, Shopify's award-winning customer service is there to help, because businesses that grow with Shopify. So no matter what you are looking to sell online or in person, Give Shopify a try today. Sign up for a $1 per month trial period at shopify.com/lawnerd. Remember, that's all lowercase. Go to shopify.com/lawnerd now to grow your business no matter what stage you're in. And you'll start hearing this sound soon. Let's get back to today's episode. I can't wait to hear your thoughts. With that, thank you for being here. Thank you for being a Lawnerd. Thank you for riding with me every day in the chat as we get through week 8 of the Commonwealth versus Karen Read. So raise your Lawnerd iridescent tumbler and say it with me. May your Wi-Fi be strong. May your toilet paper be plentiful. May your family be well. And may the odds be ever in your favor. And just for me, may your travel go smoothly. And I will keep you posted from all the things Dave Matthews Band and VidCon over on the Lawnerd app. I will see you in the next one. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com or search your app store for Lawnerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Lawnerd.